When someone decides to buy real estate and hire a Georgia real estate broker to help them with the process, they need to sign an agreement with the broker. That document is called the Exclusive Buyer Brokerage Agreement. In this lesson, we will walk through this document carefully so you will understand what each section asks for and will know how to complete the agreement when you represent buyers. We will start with Part A, Key Terms and Conditions. Section 1 is where you will document the buyer's name and the broker's name and the date the agreement will be signed. The agreement also extends to the broker's affiliated licensees. The buyer is hiring the broker to represent their interests and to help them locate and purchase real estate that meets their criteria and specific needs. When a buyer signs an exclusive brokerage agreement, they are confirming that they have the right to do so and that they are not currently subject to an exclusive agreement with any other real estate broker or agent. In Section 2, list the starting date and ending date for the agreement. If there is not a sales contract or option to purchase contract in force on the ending date, this Georgia exclusive buyer brokerage agreement will end. If, however, there is a contract in force, this agreement will be automatically extended through the date of the real estate closing. Similarly, if the buyer entered into a purchase agreement with a seller during the term of this exclusive brokerage agreement, but that purchase agreement fell through, this exclusive brokerage agreement will be automatically extended for the number of days the buyer's purchase agreement was in force. Section 3 refers to affiliated licensees of the broker who may be included as parties to the agreement, and asks the broker to indicate whether such licensees are independent contractors or employees of the broker. With respect to the broker and the broker is never an employee of the buyer. Although the real estate broker is working for the buyer's interests, their relationship is an independent contractor relationship. Section 4 asks the broker to disclose which type of agency and brokerage relationships the broker is offering. These may include seller agency, buyer agency, designated agency, dual agency, sub-agency, tenant agency, or landlord agency. If the same broker represents both the buyer and the seller in a real estate transaction, the broker is acting as a dual agent. That means the broker is representing both the buyer, who is trying to get the best possible deal on their real estate purchase, and the seller, who wants to get top dollar for their sale. This can create an inherent conflict of interest. So, if the broker practices dual agency, the buyer's signature on this agreement serves to document the buyer's understanding of the potential conflict and risks. Brokers acting as dual agents must still protect client privacy. Similarly, if the broker's agency practices designated agency, it may assign one agent to represent the buyer and another agent to represent the seller. A buyer who signs an exclusive brokerage agreement with a designated agency broker acknowledges and agrees to this practice. Section 5 addresses the commissions the buyer agrees to pay the broker. There are two parts to this section. Part A includes the agreed-upon commission that the broker is entitled to at closing, as a percentage of the sales price, a fixed dollar amount, or some other method. Typically, the real estate commissions for Georgia real estate transactions are paid by the seller. However, that is not always the case. Part B in Section 5 contemplates the possibility that the seller will not pay all of the commissions. For example, when property is sold by the owner directly and without a broker's help, an FSBO listing, sellers are sometimes unwilling to pay real estate commissions. In such cases, the buyer agrees in the exclusive brokerage agreement to pay the commission by checking the appropriate checkbox in Section 5, Part B. The buyer is also responsible for immediately paying the real estate commissions to the broker if the buyer defaults on a purchase contract for which the broker would have otherwise earned a commission. Buyers also owe brokerage commissions when they try to work directly with sellers to circumvent paying the brokerage commissions. If the buyer is leasing property from the seller, the buyer also agrees to pay the broker a separate leasing commission, in addition to and not as a replacement for the real estate commissions on the sales transaction. This is documented in Section 6. This section includes a spot to document both the dollar amount of the leasing commission, how frequently, and when the leasing commission will be paid. Section 7 specifies how long the protected period will be, in days. The protected period is a period of time after this exclusive buyer brokerage agreement ends, during which the buyer will still be responsible for paying the full amount of commission the broker would have otherwise earned, if certain conditions were met. It is important to understand that the protected period applies whether the agreement reached the ending date without a signed purchase agreement, or whether it was terminated by the parties before reaching that date. Generally speaking, a buyer may owe the broker commissions during the protected period if the buyer purchases, enters into purchase agreement, or enters into an option to purchase a contract for real estate that the buyer found out about from the broker during the term of this exclusive brokerage agreement. The same holds true even if the buyer didn't find out about the property from the broker, but did get information from the broker about the property during the term of the exclusive buyer brokerage agreement. This provision protects brokers from buyers who might decide to wait until after the expiration of their exclusive brokerage agreements before moving on with the property purchase, in an attempt to avoid paying commissions. Part B of this agreement includes more detailed information about each of the sections in Part A. It is recommended that you read through Part B to get a better understanding of each section. Now, let's turn to Part C, Other Terms and Conditions, which starts on page 3. This part of the agreement documents and clarifies some key provisions. By signing the agreement, both the broker and buyer are acknowledging their understanding of and agreement with these items. Section 1 in Part C documents the broker's responsibilities and duties toward the buyer. These duties include making required legal disclosures, working to help the buyer find real estate to purchase that meets the buyer's needs and requirements, complying with all applicable laws, and helping the buyer negotiate sales and complete a purchase and sale agreement when the buyer is ready to make an offer to a seller. Section 2 addresses the buyer's responsibilities to the broker. The broker can only help the seller if the seller is actively cooperating in the process. So buyers who sign this agreement acknowledge that they will make themselves reasonably available to view available properties to determine whether one or more of those properties meets their needs. Buyers also acknowledge their obligation to respond to communications from their broker, provide their broker with complete and relevant information, work only with the broker, who is the other party to this agreement, to understand the terms of purchase agreements and other documents related to the purchase of real estate, and to inspect and become familiar with the condition of properties they want to purchase. Buyers who sign this Georgia exclusive buyer brokerage agreement also acknowledge that they will not try to view properties being sold as SFBO, or for sale by owner, without alerting the broker, so the broker can try to enter into an agreement with the seller for a commission. In Section 3, the buyer acknowledges the broker's commitment to fair and equal housing opportunities. This exclusive buyer brokerage agreement is exclusive as to the buyer, who may not work with another broker during the term of the agreement. However, it is not exclusive to brokers. Section 4 in Part C spells this out. When a buyer signs this agreement, he or she is acknowledging that the broker might show the same property to multiple clients, that the broker does not owe any duties to the buyer, and that the broker is not responsible for making sure the buyer meets deadlines and obligations under purchase agreements or other real estate contracts. The buyer also acknowledges that the broker is not responsible for inspecting the property or for providing the buyer with information the buyer could have learned themselves from other sources. That responsibility rests with the buyer. Section 4 also explains that the broker's potential liability under this agreement is limited to the amount of commissions he or she earned from the buyer's purchase. Or if the broker did not earn any commission, his or her liability is limited to $100. The buyer also agrees to indemnify the broker and hold the broker harmless from certain legal claims arising under this agreement. Section 5 provides important promises the broker is making to the buyer. These include a statement that the broker will not knowingly provide false information, and a promise to keep information confidential if the broker knows the buyer wants that information kept quiet, unless disclosure is required by law. The broker is also promising that he or she does not have any other agency relationships that could conflict with his or her representation of the buyer, except its role in representing other buyers, sellers, landlords, and tenants. In Section 6, the buyer explicitly authorizes the broker to report suspicious activity, including potential mortgage fraud, to mortgage lenders and/or government authorities, as appropriate. The buyer acknowledges that while he or she gives the broker the authority to report such activities, the broker is nonetheless not an expert in real estate fraud matters. This means that potential fraud could go undetected and unreported, while everyday routine activities could be flagged as being fraudulent. When legal disputes occur, they can be costly and time-consuming. One popular method of resolving disputes without going to court is arbitration. Section 7 contains the same arbitration provision you have likely seen in other Georgia real estate forms and agreements. The purpose of this arbitration statement is ultimately to reduce the cost, time, and expense associated with litigating disputes in court. The parties agree that if there is a disagreement about either party's performance under the agreement, that their dispute will be heard by a mutually acceptable arbitration company in Georgia, rather than being decided by a judge and/or a jury. The arbitrator's decision will be final and will be binding on both the broker and the buyer. In a perfect world, there is never a need to enforce legal disputes. If a disagreement arises, however, this arbitration provision can be a valuable alternative dispute resolution tool. Sometimes, buyers want to buy property in a geographic area that the broker simply is not familiar with. Section 8 authorizes the broker to make referrals for the buyer so the buyer can work with someone who knows the area better. By signing this agreement, the buyer acknowledges that the broker might receive compensation for making this type of referral. Section 9 documents the buyer's acknowledgement that the broker's licensees may not have the same knowledge about properties that the broker has. In Section 10, the parties agree that Georgia law will govern the interpretation of the agreement's terms. This section also documents that there may be multiple counterparts, meaning that the parties' original signatures may be on different copies of the agreement. Section 11 says that the broker's rights to earn commissions under this agreement and the buyer's obligations to pay such commissions will continue past the expiration date or termination of the agreement. Sometimes with legal contracts, there is confusion about whether verbal statements or other promises could be considered part of the contract. Section 12 in Part C documents that this written signed agreement is the entire agreement between the parties, and that the terms of the contract can only be changed by a written amendment or modification signed by the parties. Section 13 references the Georgia Association of Realtors forms, or GAR forms, which are templates intended to help realtors. The parties acknowledge that these forms may not fit every situation, and that it might be necessary to customize a GAR form before using it. In Section 14, the parties acknowledge that communications in real estate matters are time-sensitive, and agree to try to be available during the term of this agreement so they can receive and respond to communications in a timely manner. Section 15 reiterates that time is of the essence with real estate contracts. Unfortunately, cyber fraud in real estate transactions is an ongoing concern. Fraudsters impersonate mortgage lenders, real estate brokers, or attorneys in an attempt to get unwitting buyers to wire money to them. By the time the fraud is discovered, it is often too late to recover the funds. Section 16 provides a valuable reminder and warning to be on the lookout for cyber fraud, as well as tips to help buyers avoid becoming victims of would-be fraudsters. Finally, Section 17 in Part C is a spot to indicate which other brochures or exhibits are being included in this agreement. These other exhibits and brochures are designed to give buyers who may not be real estate experts themselves information about the process, helping to make real estate transactions smoother for buyers. If you are filling out the exclusive buyer brokerage agreement, check all applicable boxes under Section 17. That's the Georgia Exclusive Buyer Brokerage Agreement. You should review the entire agreement before using it, so you understand and are comfortable with it before you use it with new clients.